Hello friends, by the initiative of Company Law Institute of India Private Limited, we have started this series on the income tax cases. In this series, today we will discuss the case of SUMIT, Export versus Assistant Commissioner of Income Tax. This case has been reported in 101 ITR Tribunal at page number 62. The matter has been decided by Mumbai ITAT and the date of the judgment is 10th November 2022. In this case, a very pertinent question has been decided by Mumbai ITAT. The question is whether the date of allotment by the builder will be taken as date of purchase by the assessee. In this case, the assessee acquired a right to purchase the property in 98-99 by making the payment of rupees 32,91,000, and the allotment was done to the assessee. After that, the assessee made various payments up to 2010 and the final payment was done in 2010. In this particular case, the builder from which the assessee acquired this right, some shares were also purchased, and that was the part of the whole agreement between the assessee and the builder. When in 2012 the assessee sold this property, the assessee calculated the long-term capital gain by taking the date of allotment as the date of the purchase. And accordingly, assessee calculated the long-term capital gain. When the assessment was going on, the assessing officer was of the view that this is not a long-term capital gain, this is the short-term capital gain. The contention of the assessing officer was that when this right to acquire the property was created, at that time there was no property in existence. Even the builder has not acquired the leasehold rights in that property. So when the property is not there, the right to acquire the property cannot be there. One issue was there in this whole case, whether the right to acquire the property is a capital asset or not. Section 2 clause 14 says about the capital asset, and section 2 subsection 47 says about the transfer of the capital asset. The capital asset definition is very wide because in that definition any kind word is there. So it means that even the right to acquire the property can be termed as a capital asset. And if we analyze the definition of transfer also given in section 2 clause 47, in that also there is word extinguishment of the rights. So it means the rights are also the capital asset. For this, there is one very important judgment of Bombay High Court which gives the definition of the capital asset and transfer and throws a very exhaustive light whether the right to acquire the property is a capital asset or not. The citation of the case is 122 ITR, page number 594. The name of the case is CIT versus Tata Services Limited. In this case, it was held that the registration of a document relates back to the day on which the agreement of sale was executed. And one more thing was that the date of allotment is the date when the right of conveyance get tested. So if we analyze the whole case, it comes out with the feeling that the date of allotment can be taken as the date of the purchase. For this, there are two important circulars of CBDT. One is issued in 1986. The circular number is 471 dated 15th October 1986, which says that the allotments done by the DDA, the date of the allotment will be taken as the date of purchase for calculating the capital gain under the Income Tax Act. But that was only for the DDA. So in 1993, one more circular was also there, the circular number 672 dated 16 December 1993, in which the CBDT said that if all the conditions of the earlier circular are fulfilled, then in other cases also, like cooperative society and other states also, the date of allotment will be taken as the date of the purchase for calculating the long-term capital gain. So in this particular case, the Bombay ITAT held that the right to acquire the property is a capital asset and the date of allotment can be taken as the date of purchase, and accordingly the capital gain can be calculated. So at the end of this video, once again I am repeating the name of the case. The name of the case is SUMIT Export versus Assistant Commissioner of Income Tax, and this case has been reported in 101 ITR Tribunal, page number 62. Thank you, friends.